And what's going on, everybody? It's Vinny Milletti with Milletti Law, the strongest name in the law. My name is Vincent Milletti. I am the owner, founder, king, lead partner, everything here at Milletti Law. It's my firm. It's my YouTube channel, my business. Okay, so make sure you subscribe to the YouTube channel below. Always be up to speed on all the updates. Make sure you go to the website, www.millettilaw.com. www.millettilaw.com. So you're up to speed, you're involved in all the updates, and you know when we're posting the videos left and right, new media content, everything. We give a lot of free stuff here. We give a lot of stuff here for free that's helpful for you. As you can see, we're broadcasting yet again from my wife's gym, simply because I have a very naughty dog in the house that doesn't want to give me 5 minutes to post without interrupting my videos. So Flex, the fuzziest name in the law, is now in the house, and I am now in the gym. So I'm not really sure how this works. I mean, as the owner of the company and the firm, I should be in the office and he should be put out. But, I don't know. At the end of the day, Fletch runs things. All right, so let's get down to it. So the whole purpose of this video was just simply, as part of this video and the last one, where I just want to kind of introduce new topics that I thought were very helpful in my practice. A lot of times things don't go as planned. Sometimes you get something known as home teams, which was very funny. Or sometimes the judges misapply the law or whatever. Sometimes it's clear on its face. Whatever the reason is, there could be a million reasons why, your injunction didn't work, or why your order show cause didn't work, or whatever, right? So this is another very helpful tool. So here, this is very helpful for when you have instances, especially now post-COVID, where things have gone stale for years. So in this instance, you have the client who had a case, the case was litigated, boom, whatever reason, they came to a resolution at some point, a very long time ago, and then now, COVID, then let's see, in my situation, COVID hit, and then everything was shut down forever, and now you have the courts opening up again, so you're trying to bring this case again, and the reality is, even though it's a pandemic, even though it's COVID, you're still facing hard restrictions, right? 1 year here, 1 year there, 2 years here, 2 years there. So in this instance, basically, when a case is inactive, so I think the section is section CPLR 3404. When a case is inactive after a year, once it's taken off the calendar, once marked as off on the calendar, after a year, it's supposed to be that's it. It's supposed to be just dismissed, and not supposed to come back online, and that's a wrap. So what you do is you file something known as a motion to restore. So in a motion to restore, you're essentially telling the court that the failure to reopen this case within a year, which is the limitations of the statute 3404. You're telling the court that, okay, we didn't give this to you within a year, but the grounds was, it was excusable, it wasn't willful, it was, we had no intention of abandoning the claim at all, we intended on diligently prosecuting this claim completely, and, and we have meritorious grounds for this complaint. So essentially, what you're doing here is, in this one, you're telling the court that, okay, fine, you admit it, you get it, there was a mistake, you didn't do it in time, whatever the case is, you understand that, but you shouldn't be dismissed on procedural grounds. Rather, you should be able to be given a shot here simply because your case was meritorious, the delay was reasonable, was excusable, you had every intention on pushing it forward, and that you didn't want to, you didn't want to let it die, and then there's one more, the one next element after that has to do with prejudice, right? That it's not prejudicial completely for the other person. So, those are really your criteria that you have to show the court in that one, and you can get a motion to restore granted. So what will wind up happening is that once a motion to restore is heard before the court, if it's unopposed by the other side, the court still has their ultimate discretion. This is basically something the court can do. The other side would jump in and respond, or whatever, if they oppose it. If they don't get wind of it, they won't respond to anything, but the court may or may not grant it. Ultimately, this is at the sound discretion of the court. This is not something that's just automatically granted, otherwise. So the way the courts look at this language is very funny. So there's a lot of litigation that goes back. What happens if you don't bring it within the year, right? So a lot of litigation goes back and forth in that. That doesn't necessarily mean you're going to lose your case just because you didn't bring it within the year. So the way the court has couched this, the literal meaning of the statute. So the statute has very firm language, but the way the court has couched the very firm language is just that rather than saying you will be denied if you don't bring it within a year, it's the presumption is that the court should be inclined to deny it, but you could certainly get over that hump. So it's basically, like I mentioned before, I do have the note here now, so I can say it a little more succinctly. It's that the plaintiff or the person moving for it needs to be able to show a meritorious cause of action, meaning that there are true defenses for it, that the defendant or the other side wouldn't be prejudiced by restoring the case to the trial calendar. Prejudice meaning substantial harm, not being able to defend themselves. And the third point is the plaintiff has the movement has an acceptable excuse for the delay and did not intend to abandon the action. So an acceptable excuse for the delay of more than 1 year with every intention to not abandon the action to bring it forward. So, I mean, those are your elements here. I think those are actually 4 elements. Those are the 4 elements here which you need to be able to show the court in order to get them to restore back to the trial calendar. I mean, it's originally, there are some instances in which you can get this done with a letter motion. Letter motion is basically you're writing a letter to the court directly, to the clerk directly, and you let them know what you want. But then there are also situations where you have to file a motion, you have to go through the whole system. And if that's the case, that's what this video is all about. So, you file your motion, right? You have your motion to put this back on the docket, to motion to restore. It comes with an affirmation, meaning that your attorney affirms the statements and signs off, or you can get an affidavit in support from your client. And then on top of that, I would always suggest just drafting up some kind of mock order that the court could just sign and put it down with your motions and papers, and that's how you do it. It takes some time to get through. I mean, I know in my situation, in my life, but even if I would put like a late notice period, a late time period for them to respond, and the judge would still, there'd be hearing just on the motions. There'd be no hearing. The ruling would be just based on the motions. There'd be no hearing, and then you would just go on from there. Then you would just notice at some point it's either rejected or granted down the road. So just the process kind of just moves on its own, unless the other side actually opposes. And I've only had to use these in reality in situations where the other side is so quiet. So I mean, I guess that's one of the formalities. I guess that's a good thing for you, right? Because you're not really going up against anybody here, but whatever. So, but that's the whole point of this video. The whole point of this video is if you fail to bring a claim in the allotted time within 1 year, whatever activity occurs, then it gets marked off the calendar. All is not lost. Let your heart not be troubled. You still have options. You can still do a motion to restore to the trial calendar. Like you still have options to save and preserve the situation. So don't lose hope and make sure you get your motions out there. So this was the second of what I thought were 2 very helpful pieces of information for me that I'm sharing with you. I think it'd be helpful for you too if you happen to have a client that got caught up in COVID or whatever the case is and didn't follow for a little while, then I need action. So of course, if you have any questions, concerns, if you need anything on our end, obviously you can reach out to us. You can go to the website. You can go to basically whatever you like. any way you want to reach us, we're happy to reach out to you in any way. Hopefully you're subscribing, hopefully you're on the newsletter, so it's all there too. And if you have any questions, obviously let us know. So yours in laws, love and lives. Enjoy your new year. It is now January 2nd, 2022. It is a Sunday. If you're not hungover, intoxicated, hopefully you're doing something that makes a lot of money and is awesome. And that's it. So if you need anything, questions, you know where we are. Have a wonderful day.